Hey folks, welcome to the Law of Self-Defense Show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you very much, and welcome to part 1 of 4 of my reading of D.C. v. Heller, the first of 3 seminal U.S. Supreme Court Second Amendment cases that I'll be reading in the coming days. Here we go. Hey folks, if you like this Law of Self-Defense content, and I know you do, that's why you're here, you may as well consider picking up a free copy of our best-selling book, The Law of Self-Defense Principles. It's a real physical book. It's not just a PDF download. You can check it out on Amazon, where it's 5-star rated, over 1,400 reviews, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. We only ask that you cover the cost of shipping the book to you. The book itself is free. You can get this book, learn more about it at lawofselfdefense.com/free book. Hey folks, welcome to today's Law of Self-Defense show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you very, very much for your support. Today's show is part of a continuing series of Second Amendment U.S. Supreme Court decisions. The 3-part series is really District of Columbia v. Heller. Then we have the McDonald decision, and finally the Bruin decision. And I am recording those out of order. So as you watch these 3 shows, actually there'll be much more than 3 shows because each opinion is so long that each opinion's chopped up into multiple shows. But as you observe them, you'll see that I recorded these out of chronological sequence. We'll just have to learn to live with it. I've previously recorded Bruin, so that'll be available shortly. This show begins the start of my reading of District of Columbia v. Heller, the first of the 3 major U.S. Supreme Court decisions in the last 20 years. So this Heller decision came out of the U.S. Supreme Court in 2008. It was a consequence of a court of appeals, a federal court of appeals decision that favored the District of Columbia. By the way, there was a dissent in that 3-judge Court of Appeals decision that preceded this one, and that dissent was written by Judge Kavanaugh, who would go on to be seated on the U.S. Supreme Court, is currently seated on the U.S. Supreme Court, and voted favorably for the Second Amendment in the more recent Bruin decision. But here we are back in 2008, and the Supreme Court had not taken on a substantive Second Amendment case in many, many, many years. This decision will be written by Justice Scalia. He would die 8 years after this decision, unfortunately. Obviously no longer on the U.S. Supreme Court, having passed away. But it's one of the most seminal Second Amendment decisions from the U.S. Supreme Court in my lifetime, and I thought it important to make a record of it for the Law of Self-Defense community. We're not really a gun community per se. We're a self-defense, defense of others, defense of property community. But of course, guns are often the most common and most reliable forms of defending self, others, and property. So these Second Amendment privileges are very important to us as well. So, District of Columbia v. Heller. Specifically, Heller was a gentleman, Dick Anthony Heller, Richard Heller. I actually had the opportunity to meet Richard at one of the NRA annual meetings a few years after this event. Very nice gentleman. District of Columbia v. Dick Anthony Heller in a decision handed down June 26, 2008. Now, as always in these decisions, they list the counsel for the parties involved. The petitioners here are the District of Columbia, and essentially the respondents are Dick Heller. So it's D.C. versus Heller. And I don't normally read out the counsel because they normally don't matter. But I think it's worth noting the counsel in this case because of how disparate the weight of counsel was. So for the respondent, for Dick Heller, the man seeking to assert his Second Amendment rights, we have attorney Alan Gura. Alan Gura is a outstanding, vigorous lawyer defender of the Second Amendment. If you don't know who Alan Gura is, you're doing yourself a disservice. But Alan Gura here was the counsel of record along with Robert Levy and Clark Neely, all from the Gura and Pozeski law firm in Alexandria, Virginia. So 3 lawyers there on behalf of Dick Heller, seeking to assert his Second Amendment rights before the U.S. Supreme Court. Who was on the other side? On the other side, we had Thomas Goldstein, Christopher Eggleston, both of Aiken, Gump, Strauss, Hauer, and Feld, a prominent Washington, D.C. firm, Walter Dillinger, Matthew Shores, Mark Davies, Brian Gurrid, Joseph Blocher. Many of these are not admitted to practice in D.C., so they were admitted just for this case. We have Peter Nichols, an interim attorney general. We have Todd Kim, a solicitor general. We have Donna Muraski, a deputy solicitor general. We have Lutz Prager, Office of the Attorney General for D.C. We have Robert Long, Jonathan Marcus of Covington and Burling, Washington, D.C. We have Frederick Whitmer of Thiel and Reed Brown, Raisman and Steiner, a New York law firm. We have Charles Dyke of Thiel Reed Brown, Raisman and Steiner of San Francisco. We have Charles English, Jeffrey Gans, Elizabeth Wash, Emily Jones, Laura Bourgoy of Thiel and Reed Brown, Raisman, Steiner, Washington, D.C. We have Dennis Barron, Richard Bailey, and Jeffrey Kaplan of Supporters of Petitioners. Those are all PhDs in support of Washington, D.C. So we had 3 lawyers supporting Dick Heller in asserting his Second Amendment rights against the United States government. And on the other side, we had a couple of dozen very high caliber, I shouldn't say high caliber, very prominent lawyers from very prominent firms. Just pointing that out, the disparity of legal forces brought to bear in this argument. This was, by the way, a 5-4 decision. The majority was Scalia, Roberts, Kennedy, Thomas, and Alito. Of course, Thomas would go on to write the majority decision in the more recent Bruen case last year, 2022. Scalia, as I mentioned, would die about 8 years after this event in 2016, after this decision. There was a 4-justice dissent in Heller, and that was Stevens, Souter, Ginsburg, and Breyer, none of whom are now currently on the Supreme Court. Breyer was on the Supreme Court for the 2022 Bruen decision. He wrote the dissent in the Bruen decision. But none of those other justices in the dissent of Heller were on the Supreme Court for Bruen, and even Breyer is now off the Supreme Court, having retired shortly after the Bruen decision. So Justice Scalia delivered the majority opinion of the court. I'll begin reading that decision now. We consider whether a District of Columbia prohibition on the possession of usable handguns in the home violates the Second Amendment to the Constitution. The District of Columbia generally prohibits the possession of handguns. It is a crime to carry an unregistered firearm, and the registration of handguns is prohibited. Wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for 1-year periods. District of Columbia law also requires residents to keep their lawfully owned firearms, such as registered long guns, unloaded and disassembled or bound by a trigger lock or similar device unless they are located in a place of business or being used for lawful recreational activities. Respondent Dick Heller is a D.C. special police officer authorized to carry a handgun while on duty at the Federal Judicial Center. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. He thereafter filed a lawsuit in the Federal District Court for the District of Columbia seeking, on Second Amendment grounds, to enjoin the city from enforcing the bar on the registration of handguns, the licensing requirement insofar as it prohibits the carrying of a firearm in the home without a license, and the trigger lock requirement insofar as it prohibits the use of functional firearms within the home. The district court dismissed respondent's complaint. See Parker v. District of Columbia. The Court of Appeals for the District of Columbia Circuit, construing his complaint as seeking the right to render a firearm operable and carry it about his home in that condition only when necessary for self-defense, reversed. See Parker v. District of Columbia, 478 Federal 3rd 370, 2007. It held that the Second Amendment protects an individual right to possess firearms and that the city's total ban on handguns, as well as its requirement that firearms in the home be kept non-functional, even when necessary for self-defense, violated that right. The Court of Appeals directed the District Court to enter a summary judgment for the respondent, Heller. We, the Supreme Court, granted certiorari, 2007. We turn first to the meaning of the Second Amendment. The Second Amendment provides, quote, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, close quote. In interpreting this text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary, as distinguished from technical meaning. Normal meaning may, of course, include an idiomatic meaning, but it excludes secret or technical meanings that would not have been known to ordinary citizens in the founding generation. The two sides in this case have set out very different interpretations of the amendment. Petitioners, and today's dissenting justices, believe that it protects only the right to possess and carry a firearm in connection with militia service. Respondents argues that it protects an individual right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes such as self-defense within the home. The Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but rather announces a purpose. The amendment could be rephrased, quote, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, close quote. Although this structure of the Second Amendment is unique in our Constitution, other legal documents of the founding era, particularly individual rights provisions of state constitutions, commonly included a prefatory statement of purpose. Logic demands that there be a link between the stated purpose and the command. The Second Amendment would be nonsensical if it read, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to petition for redress of grievances shall not be infringed, close quote. That requirement of logical connection may cause a prefatory clause to resolve an ambiguity in the operative clause. Quote, the separation of church and state being an important objective, the teachings of canon shall have no place in our jurisprudence, close quote. The preface makes clear that the operative clause refers not to the canons of interpretation, but to clergymen. But apart from that clarifying function, a prefatory clause does not limit or expand the scope of the operative clause. It is nothing unusual in acts for the enacting part to go beyond the preamble. The remedy often extends beyond the particular act or mischief which first suggested the necessity of the law. Therefore, while we begin our textual analysis with the operative clause, we will return to the prefatory clause to ensure that our reading of the operative clause is consistent with the announced purpose. Operative clause. Right of the people. The first salient feature of the operative clause is that it codifies a right of the people. The unamended Constitution and the Bill of Rights use the phrase right of the people 2 other times, in the First Amendment's Assembly and Petition Clause, and in the Fourth Amendment's Search and Seizure Clause. The Ninth Amendment uses very similar terminology. Quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Close quote. All 3 of these instances unambiguously refer to individual rights, not collective rights, or rights that may be exercised only through participation in some corporate body. 3 provisions of the Constitution refer to the people, in a context other than rights. The famous preamble, "We the people," Section 2 of Article 1, providing that the people will choose members of the House, and the 10th Amendment, providing that those powers not given the federal government remain with the states or the people. Those provisions arguably refer to the people acting collectively, but they deal with the exercise or reservation of powers, not rights. Nowhere else in the Constitution does a right attributed to the people refer to anything other than an individual right. What is more, in all 6 other provisions of the Constitution that mention the people, the term unambiguously refers to all members of the political community, not an unspecified subset. As we said in United States v. Verdugo-Urquidez, quote, "The people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and 10th Amendments, refers to a class of persons who are part of a national community, or who have otherwise developed sufficient connection with this country to be considered part of that community." Close quote. This contrasts markedly with the phrase "the militia" in the prefatory clause. As we will describe below, the militia in colonial America consisted of a subset of the people, those who were male, able-bodied, and within a certain age range. Reading the Second Amendment as protecting only the right to keep and bear arms in an organized militia therefore fits poorly with the operative clause's description of the holder of that right as the people. We start, therefore, with a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans. Keep and bear arms. We move now from the holder of the right, the people, to the substance of the right, to keep and bear arms. Before addressing the verbs keep and bear, we interpret their object, arms. The 18th century meaning is no different from the meaning today. The 1773 edition of Samuel Johnson's dictionary defined arms as weapons of offense or armor of defense. Timothy Cunningham's important 1771 legal dictionary defined arms as anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. The term was applied, then as now, to weapons that were not specifically designed for military use and were not employed in a military capacity. For example, Cunningham's legal dictionary gave as an example of usage, quote, "Servants and laborers shall use bows and arrows on Sundays and not bear other arms," close quote. Although one founding-era thesaurus limited arms, as opposed to weapons, to, quote, "instruments of offense generally made use of in war," close quote, even that source stated that all firearms constituted arms. Some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. We turn to the phrases keep arms and bear arms. Johnson defined keep as, most relevantly, to retain, not to lose, and to have in custody. Webster defined it as to hold, to retain in one's power or possession. No party has apprised us of an idiomatic meaning of keep arms. Thus, the most natural reading of keep arms in the Second Amendment is to have weapons. The phrase keep arms was not prevalent in the written documents of the founding period that we have found, but there are a few examples, all of which favor viewing the right to keep arms as an individual right unconnected with militia service. William Blackstone, for example, wrote that Catholics convicted of not attending service in the Church of England suffered certain penalties, one of which was that they were not permitted to keep arms in their houses. Petitioners point to militia laws of the founding period that required militia members to keep arms in connection with militia service, and they conclude from this that the phrase keep arms has a militia-related connotation. This is rather like saying that since there are many statutes that authorize aggrieved employees to file complaints with federal agencies, the phrase file complaints has an employment-related connotation. Keep arms was simply a common way of referring to possessing arms for militiamen and everyone else. At the time of the founding, as now, to bear meant carry. When used with arms, however, the term has a meaning that refers to caring for a particular purpose, confrontation. In Muscarello v. United States, in the course of analyzing the meaning of carries a firearm in a federal criminal statute, Justice Ginsburg wrote that surely a most familiar meaning is, as the Constitution's Second Amendment indicates, wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. We think that Justice Ginsburg accurately captured the natural meaning of bear arms. Although the phrase implies that the carrying of the weapon is for the purpose of offensive or defensive action, it in no way connotes participation in a structured military organization. From our review of founding-era sources, we conclude that this natural meaning was also the meaning that bear arms had in the 18th century. In numerous instances, bear arms was unambiguously used to refer to the carrying of weapons outside of an organized militia. The most prominent examples are those most relevant to the Second Amendment. 9 state constitutional provisions written in the 18th century or the first 2 decades of the 19th century, which enshrined a right of citizens to bear arms in defense of themselves and the state, or bear arms in defense of himself and the state, it is clear from those formulations that bear arms did not refer only to carrying a weapon in an organized military unit. Justice James Wilson interpreted the Pennsylvania Constitution's arms-bearing right, for example, as a recognition of the natural right of defense of one's person or house, what he called the law of self-preservation. That was also the interpretation of those state constitutional provisions adopted by pre-Civil War state courts. These provisions demonstrate, again in the most analogous linguistic context, that bear arms was not limited to the carrying of arms in a militia. The phrase bear arms also had, at the time of the founding, an idiomatic meaning that was significantly different from its natural meaning. Quote, to serve as a soldier, do military service, fight, close quote, or, quote, to wage war, close quote. But it unequivocally bore that idiomatic meaning only when followed by the preposition against, which was in turn followed by the target of the hostilities. Every example given by petitioners' amici for the idiomatic meaning of bear arms from the founding period either includes the preposition against or is not clearly idiomatic. Without the preposition, bear arms normally meant, as it continues to mean today, what Justice Ginsburg's opinion in Muscarello said. In any event, the meaning of bear arms that petitioners and Justice Stevens propose is not even the, sometimes, idiomatic meaning. Rather, they manufacture a hybrid definition, whereby bear arms connotes the actual carrying of arms, and therefore is not really an idiom, but only in the service of an organized militia. No dictionary has ever adopted that definition, and we have been apprised of no source that indicates that it carried that meaning at the time of the founding. But it is easy to see why petitioners and the dissent are driven to the hybrid definition. Giving bear arms its idiomatic meaning would cause the protected right to consist of the right to be a soldier or to wage war, an absurdity that no commentator has ever endorsed. Worse still, the phrase keep and bear arms would be incoherent. the word arms would have two different meanings at once. Weapons as the object of keep, and as the object of bear, one half of an idiom. It would be rather like saying he filled and kicked the bucket to mean he filled the bucket and died. Grotesque. Petitioners justify their limitation of bear arms to the military context by pointing out the unremarkable fact that it was often used in that context, the same mistake they made with respect to keep arms. It is especially unremarkable that the phrase was often used in a military context in the federal legal sources, such as records of congressional debate, that have been the focus of petitioners' inquiry. Those sources would have had little occasion to use it except in discussions about the standing army and the militia. And the phrases used primarily in those military discussions include not only bear arms, but also carry arms, possess arms, and have arms, though no one thinks that those other phrases also had special military meanings. The common references to those fit to bear arms in congressional discussions about the militia are matched by use of the same phrase in the few non-military federal contexts where the concept would be relevant. Other legal sources frequently used bear arms in non-military contexts. Cunningham's legal dictionary, cited above, gave as an example of its usage a sentence unrelated to military affairs. Quote, "Servants and laborers shall use bows and arrows on Sundays and not bear other arms." Close quote. And if one looks beyond legal sources, bear arms was frequently used in non-military contexts. Justice Stevens points to a study by Amici supposedly showing that the phrase bear arms was most frequently used in the military context. Of course, as we have said, the fact that the phrase was commonly used in a particular context does not show that it is limited to that context, and in any event, we have given many sources where the phrase was used in non-military contexts. Moreover, the study's collection appears to include, who knows how many times, the idiomatic phrase bear arms against, which is irrelevant. The amici also dismiss examples such as bear arms for the purpose of killing game, because those uses are, quote-unquote, expressly qualified. This analysis is faulty. A purposive qualifying phrase that contradicts the word or phrase it modifies is unknown this side of the looking glass, except, apparently, in some courses on linguistics. If bear arms means, as we think, simply the carrying of arms, a modifier can limit the purpose of the carriage, quote, for the purpose of self-defense, close quote, or, quote, to make war against the king, close quote. But if bear arms means, as the petitioners and the dissent thinks, the carrying of arms only for military purposes, one simply cannot add for the purpose of killing game. The right to carry arms in the militia for the purpose of killing game is worthy of the Mad Hatter. Thus, these purposive qualifying phrases positively establish that to bear arms is not limited to military use. Justice Stevens places great weight on James Madison's inclusion of a conscientious objector clause in his original draft of the Second Amendment. Quote, "But no person religiously scrupulous of bearing arms shall be compelled to render military service in person." Close quote. He argues that this clause establishes that the drafters of the Second Amendment intended bear arms to refer only to military service. It is always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process. In any case, what Justice Stevens would conclude from the deleted provision does not follow. It was not meant to exempt from military service those who objected to going to war, but had no scruples about personal gunfights. Quakers opposed the use of arms not just for militia service, but for any violent purpose whatsoever. So much so that Quaker frontiersmen were forbidden to use arms to defend their families, even though, in such circumstances, the temptation to seize a hunting rifle or knife in self-defense must sometimes have been almost overwhelming. The Pennsylvania Militia Act of 1757 exempted from service those scrupling the use of arms, a phrase that no one contends had an idiomatic meaning. Thus, the most natural interpretation of Madison's deleted text is that those opposed to carrying weapons for potential violent confrontation would not be compelled to render military service in which such carrying would be required. Finally, Justice Stevens suggests that keep and bear arms was some sort of term of art, presumably akin to hue and cry or cease and desist. This suggestion usefully evades the problem that there is no evidence whatsoever to support a military reading of keep arms. Justice Stevens believes that the unitary meaning of keep and bear arms is established by the Second Amendment's calling it a right, singular, rather than rights, plural. There is nothing to this. State constitutions of the founding period routinely grouped multiple related guarantees under a singular right, and the First Amendment protects the right, singular, of the people peaceably to assemble and to petition the government for a redress of grievances. And even if keep and bear arms were a unitary phrase, we find no evidence that it bore a military meaning. Although the phrase was not at all common, which would be unusual for a term of art, we have found instances of its use with a clearly non-military connotation. In a 1780 debate in the House of Lords, for example, Lord Richmond described an order to disarm private citizens, not militia members, as a violation of the constitutional right of Protestant subjects to keep and bear arms for their own defense. In response, another member of Parliament referred to the right of bearing arms for personal defense, making clear that no special military meaning for keep and bear arms was intended in the discussion. Meaning of the operative clause. Putting all of these textual elements together, we find that they guarantee the individual right to possess and carry weapons in case of confrontation. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and Fourth Amendments, codified a pre-existing right. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it shall not be infringed. As we said in United States v. Cruikshank, 1876, this is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed. Between the Restoration and the Glorious Revolution, the Stuart kings, Charles II and James II, succeeded in using select militias loyal to them to suppress political dissidents, in part by disarming their opponents. Under the auspices of the 1671 Game Act, for example, the Catholic James II had ordered general disarmaments of regions home to his Protestant enemies. These experiences caused Englishmen to be extremely wary of concentrated military forces run by the state and to be jealous of their arms. They accordingly obtained an assurance from William and Mary in the Declaration of Right, which was codified as the English Bill of Rights, that Protestants would never be disarmed. Quote, that the subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law. Close quote. This right has long been understood to be the predecessor to our Second Amendment. It was clearly an individual right, having nothing whatever to do with service in a militia. To be sure, it was an individual right not available to the whole population, given that it was restricted to Protestants, and like all written English rights, it was held only against the Crown, not Parliament. But it was secured to them as individuals, according to libertarian political principles, not as members of a fighting force. By the time of the founding, the right to have arms had become fundamental for English subjects. Blackstone, whose works, we have said, constituted the preeminent authority on English law for the founding generation, cited the arms provision of the Bill of Rights as one of the fundamental rights of Englishmen. His description of it cannot possibly be thought to tie it to militia or military service. It was, he said, quote, the natural right of resistance and self-preservation, close quote, and, quote, the right of having and using arms for self-preservation and defense, close quote. Other contemporary authorities concurred. Thus, the right secured in 1689 as a result of the Stuarts' abuses was by the time of the founding understood to be an individual right, protecting against both public and private violence. And, of course, what the Stuarts had tried to do to their political enemies, George III had tried to do to the colonists. In the tumultuous decades of the 1760s and 1770s, the Crown began to disarm the inhabitants of the most rebellious areas. That provoked polemical reactions by Americans invoking their rights as Englishmen to keep arms. A New York article of April 1769 said that, quote, "It is a natural right which the people have reserved to themselves, confirmed by the Bill of Rights, to keep arms for their own defense." Close quote. They understood the right to enable individuals to defend themselves. As the most important early American edition of Blackstone's Commentaries by the law professor and former anti-federalist St. George Tucker made clear in the notes to the description of the arms right, Americans understood the right of self-preservation as permitting a citizen to repel force by force when the intervention of society in his behalf may be too late to prevent an injury. There seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms. Of course, the right was not unlimited, just as the First Amendment's right of free speech was not. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation, just as we do not read the First Amendment to protect the right of citizens to speak for any purpose. Before turning to limitations upon the individual right, however, we must determine whether the prefatory clause of the Second Amendment comports with our interpretation of the operative clause. And that's it for part 1 of 4 of my reading of D.C. v. Heller, a U.S. Supreme Court seminal Second Amendment decision. Next time we meet, I'll be reading part 2 of 4. If you like this kind of content, and I know you do, that's why you're here, you may as well consider becoming a Law of Self-Defense member. It's dirt cheap to at least try it out. You can get a 2-week trial membership for only 99 cents. Just go to lawofselfdefense.com/trial to sign up for that. In the unlikely event you don't like it and you'd like your money back, we'll give you a 200% refund. Most people, almost everyone, stays a member, and just being a standard member of Law of Self-Defense is dirt cheap. It's only about 30 cents a day, less than $10 a month. To be a member of Law of Self-Defense, get unlimited access to all our members-only content. It's the only way to have your comments and questions on live streams be addressed by me. You get a members-only podcast. Much of our content is limited, so only members can access it. Get all that and much more at lawofselfdefense.com/trial. Just try it out for 2 weeks, 99 cents, 200% money back guarantee. It's a negative risk opportunity. I hope you see you as a member real soon.